All right, I love some of the ridiculous requests for courtroom scenes that I've gotten, but this has got to be by far one of my favorites. Today we are doing Bluey Season 3, Episode 27, Family Meeting.
It means you both get to tell your side of the story, and then I decide who's telling the truth, okay?
Yes, Your Honour.
Ooh, I like that. Fourth rule, everyone calls me Your Honour. Okay, Bluey, you first.
Yes, Your Honour.
So interesting thing here. Okay, yeah, we're talking about a cartoon, but actually that gets a little bit of realistic courtroom preparation. Okay, so before a jury comes in, there will be, and maybe even before the trial even starts, you're gonna have the attorneys deciding on what are we gonna call that? How are we gonna discuss this? What's a word to appropriately describe that in front of the jury? A lot of that happens just before the jury even comes in so that they don't hear any of that. So interestingly enough, these cartoon dogs actually got something pretty right.
This is you asleep. This is me.
And where was Dad?
Here.
Hey, Your Honour.
I'll allow it.
All right, objection. Yeah, Bandit's not gonna be happy. He's accused of fluffying in Bluey's face, and Bluey, to show a reenactment for the jury, of course, which is actually, this would be a bench trial, right? Because Chili is being the judge and there is no jury, so Chili is in fact being the trier of fact, or the person that gets to decide what happened. In felony cases, the trier of fact is a jury. But bench trials, misdemeanor cases, yeah, there are no jury, judge-only trials that happen all the time. Okay, now Bandit is pretty upset because for the reenactment, Bluey is using a skunk to depict him. Well, that's important. It implies something for the trier of fact, right? He's accused of a fluffy, and Bluey is using something stinky to depict him. So yeah, I would have probably objected to that too, and frankly I think Bandit's got some grounds for appeal here.
I've heard enough.
Hey, hang on.
Oh yeah, your side. Make it quick.
Here, give me it. Check it. Mum.
All right, now I'm thinking that Chili should have recused herself from this case since she is the mother or wife of literally everybody involved. And she's also showing, yeah, she already doesn't believe Bandit. She's got some very clear biases here, so probably should have recused herself. Now I'm gonna tell you, in case you didn't live in Australia for 2 years like I did, you may not know what a fluffy is. Okay, fluffy is in fact the Australian word for flatulence. They have several of them, but that is one of them, and we're talking about a kids show, so they're using one of the cute ones.
Was here sleeping, looking gorgeous as usual.
Oh well.
Hey, you're trying to make Mum like you more.
Yeah, flirting with the judge, typically not advisable. Now, in a family mock trial, maybe you get away with it. I'd probably give it a shot. Why not? But yeah, I'm going to say don't do that on a regular basis or in any other normal situation. Free legal advice. Don't try flirting with the judge.
Ooh, I've got an idea. Is this what you had for breakfast yesterday? Baked beans on wheat toast?
Yep.
Bingo. What's the fluffy level on this? High. Thank you.
Okay, so here, bingo, little sister is actually being called in as an expert witness. You wouldn't be questioning Bandit and your expert witness at the same time. You'd gather Bandit's testimony. What did you have for breakfast? What did you have for lunch? What did you have for dinner last night? And then you would call your expert witness. Okay, bingo. What is the fluffy level of those meals? And bingo could testify to that. Expert witnesses are used all the time in all kinds of capacities, for civil trials, for criminal, lot of ways. So again, cartoon dogs really getting it right.
You Dad fluffy in my face? Yes, I did.
Oh, what? Bingo, you weren't even there.
Yes, I was. Thank you, Bingo. You can leave.
Okay, now, all right, well, bingo actually can't leave because bingo still needs to be cross-examined, right? Now, originally, you were seeing at the beginning of the episode, Bandit and Bluey are actually arguing with each other whether this fluffy even occurred, okay? And now, all of a sudden, Bingo is saying, yeah, I was there and I actually saw it. Of course you're going to want to cross-examine that witness. Bandit's going to want to question Bingo here to say, well, you weren't even there, right? But of course, if he says you weren't even there, then he's sort of admitting that there was some type of event. So he would want to set it up to say, oh, Bingo, it's Bingo here. Bingo, what was your morning like? Bingo might say, oh, I woke up and I ate breakfast and then I watched cartoons. And oh, there's no TV in the bedroom, so you couldn't have been there, right? That kind of thing. But Bingo definitely needs to be cross-examined here because her testimony takes this from a he said, she said case to a two witnesses probably actually could convict on this. By the way, the statute, I think, that Bandit is facing here, I think I'll pop this up on the screen there. This is, in fact, let's see, what was this called? This is the Public Air Purity and Decorum Act. And as it states that this is enacted by the people of no real or actual jurisdiction. But as you can see here, it's got definitions for a public space. It defines what a fluffy is. Okay, so as you can see in section 2 here, it says the legislature finds that the emission of fluffies in public space can be disruptive and detrimental to the comfort and well-being of the general public. To preserve public space, maintain standards of hygiene, and foster a more pleasant environment for all citizens, the legislature hereby declares it necessary to regulate such emissions. That seems perfectly fair to me. And a lot of our laws start with this type of, hey, this is why we're enacting this legislation. And then we get down here to section 4, subsection A. It shall be unlawful for any person to willfully or negligently emit a fluffy in public space. Okay, pretty straightforward, right? You know you're not supposed to do it. You can't do it in public. Then, of course, we get down here in subsection E, aggravated offenses. Okay, so these other ones, those were misdemeanor offenses, but here, if the fluffy was intentionally directed at a specific person or group of persons with the intent to cause physical harm or substantial offense, okay, well, I don't know how you prove substantial offense. Not sure that part is very threatening, but as far as Bandit is concerned, bad news for him. Subsection Romanet 6 here, if the fluffy was discharged within 12 inches of the face of another individual, that is an aggravated offense. And then you can see here, it says that a person found guilty under sections Romanet 6 or 7 is guilty of a Class 5 felony offense. So this is a serious situation. Bandit is on trial here for a Class 5 felony offense. Okay, now you could probably tell that this is a joke. I had AI draft this for me. But AI actually did a really good job, so much so that to the extent that I looked at this and went, wow, this actually reminds me a lot of our Arizona assault statute. Now, our Arizona assault statute does not say that it is in fact a crime to fluffy at or near somebody or anything like that. But it starts with a very, very minor offense. In fact, assault can be just a threat. And if it is just a threat, it's a misdemeanor 3, the lowest crime possible. Then you actually get to physical contact, and that is a misdemeanor 1. Okay, and then you have aggravating factors. And there's a list of maybe 40 or 50 aggravating factors in the Arizona assault statute. And if one of those applies, it could be any it could go from felony 6 all the way up to felony 2, depending on which one of those aggravating factors apply. A list of them is you used a deadly weapon. Most people are familiar with that one. If you went into a residential home of another to commit the crime. If it's committed against a peace officer or a prosecutor, not me, not a defense attorney. The prosecutors get protection. I don't. But if it's against a prosecutor in the course of their regular duties, that's an aggravating factor. So AI actually did something really real here in helping our cartoon dogs bring their story to real life. Generated what's really a great statute. But anyway, so back to the fact, Bennett's in a lot of trouble here. Now, another interesting bit. Okay, so Judge Mom Chili here says, okay, everybody forget that bit. Well, that wouldn't happen in a normal courtroom, right? Well, yeah, actually it does. People give testimony all the time, and then a attorney says objection and presents a reasonable argument for the objection, and the judge says, I am instructing the jury to disregard the testimony that they heard. How the heck do you do that? How the heck do you forget that you actually heard testimony from somebody about a particular topic? Which is why they actually hear those motions that I mentioned earlier, the hearing motions and things like that before the jury even comes in. Typically speaking, you want to resolve all that stuff off the record so that the jury doesn't hear it, so that the defendant doesn't have an appeal later on that they can say, look, the jury heard it and they can't forget that kind of stuff. So, but in this case, Judge Mom just says, everybody forget that they heard that because Bingo got paid off to testify.
Me?
Mrs. Healer, on the morning of this morning, you didn't hear me, Fluffy, did you?
No.
Let's repeat that. You didn't hear me, Fluffy.
'Cause she was asleep.
Objection, repetition. He can't ask that same question twice. It's been asked and answered already. Move along, Bandit.
And he has to move the table to get it. And it makes this horrible scraping sound like... Oh, no.
He didn't move the table. That sound was to Fluffy. Ah, Bandit!
Well, maybe we should hear from, that guy.
What guy? Ah! He's running away! Get him, King!
You'll never get me alive!
Okay, so how about the question of can a judge testify to issues at a trial? No, they couldn't, but could a judge actually testify if they had some other piece of information that was relevant to the trial, but it's not actually a fact of the trial? We actually have rules for a judge testifying. Just say maybe a judge saw an attorney talking to, I think this was an example we had in law school, an attorney is talking to one of the juries or jurors outside of the courtroom. The judge might actually have to testify to that to get that juror dismissed. So there are actual rules for that, but could they testify to the facts relevant to the case? No, they couldn't. So Cartoon Dogs didn't get it right there.
Freedom! Get off me!
Is there something you'd like to say?
Whoever smelt it, dealt it?
Mr. Healer,
Okay. I fluffied.
in your child's face.
The face is at bum level. It's hard not to.
Okay. So unfortunately, Bandit just admitted on the record to one of those aggravating factors. He should have seen if he could have gotten away with the misdemeanor offense, but nope. Instead, they bring him in. He's all tied up with a jump rope. Looks like they're moving to sentencing. They've already found him guilty. So here's the thing. After you've been found guilty, that is when people finally will say, yeah, in fact, I was guilty. Because you can't be less guilty than guilty. People take a plea, people get found guilty, and then they go to sentencing and say, yep, okay, I was guilty, and I'm accepting responsibility for what I did. Typically, accepting responsibility follows a plea agreement, not a guilty verdict at trial. Because if you went all the way to verdict at trial, it's because you were trying to deny what you did. So, but accepting responsibility, actually one of the biggest mitigating factors that there is at sentencing. So, and I've mentioned it before, but I won't ever tell people to say, I'm sorry and I'll never do it again, but I will say, how do you feel about the offense? Do you think you would ever do anything like this again? And if they tell me, I'm really sorry, I'm accepting responsibility for it, and I'll never do anything like that again, then I will say, okay, good. Go tell that to the judge because that's going to help you a lot.
Bluey?
Okay, I was playing computer games on the tablet.
Even though Mum said you weren't allowed to play computer games until the weekend?
Yes.
Bluey Christine Healer. I sentence both of you to horsey rides. Saddle up, Bingo.
Hooray!
Hey!
I'm sorry, Dad.
All right, so suddenly Bluey goes on trial. A very, very brief trial for Bluey, but somehow she's found guilty at the same time that Dad is. Not usually going to happen. Usually got to charge. If there is a new defendant that pops up, a lot of times a defense for a case is, I didn't do it, he did, or she did, or whatever. And if that actually pops up and during the trial the police say, oh, there's actually enough evidence to charge that other person, they're going all the way back to step A, charging that person, issuing an indictment, going through 3 or 4 pretrial conferences, scheduling trial, going to trial. So yeah, won't happen that you're just found guilty at somebody else's trial. Okay, hope you liked the Cartoon Dogs courtroom scene. That was Bluey Season 3, Episode 27. Hope you enjoyed it.